Doctors who have been arrested often ask, "Do I have to report my arrest to the California Medical Board?" The answer is yes, but only sometimes. The Medical Board of California follows Business and Professions Code Section 802.1. This self-reporting statute requires a doctor to report any indictment or information charging a felony against the licensee. It also requires the doctor to report any conviction, even if the doctor entered a plea of guilty or no contest. This has to be done within 30 days of when the event takes place. What is not required is reporting an arrest. An arrest does not trigger the reporting requirement even if the arrest is for a serious crime. Showing up in court does not trigger the reporting requirement. Entering a plea of not guilty does not create an obligation to self-report to the medical board. Reporting is required in only 3 situations. First, there is a requirement to report whenever there is a conviction. Second, in felony cases, if a grand jury issues an indictment, the doctor must self-report. Third, in a felony case, there is a process called a preliminary hearing. This is a hearing where a judge reviews the evidence. If the judge finds that the evidence raises a reasonable suspicion that the doctor has committed a crime, the prosecution can file charges in a document called an information. That event, the filing of the information, must be self-reported. Unfortunately, even if charges are dismissed and the doctor has no reporting requirement, the California Department of Justice may report the case to the Medical Board of California. If that happens, the doctor must defend himself or herself against a board inquiry.
Daniel Horowitz is a state of California criminal defense specialist. He is certified by the Board of Legal Specialization. If you are a physician charged with a crime, call Daniel for a physician-specific defense. Daniel's number is 925-283-1863. That's 925-283-1863. Thank you.